My lord, may I take a leave to mention a AP 324 of 2024, my lord. My learned friend is other side, my lord. This is the appeal against the Section 9 order. In this, my lord, this court was pleased to dispose of the matter with a direction that the appellant will secure a 5 crore of a security, my lord. And the matter was with a registrar insolvency in charge, my lord. But the registrar insolvency in charge has given a direction to the matter be placed before this court, my lord. But matter had not appeared till date, my lord. So I have given a notice to my learned friend.
I'm appearing for the appellants, my lord. I'm
So
the
my
appellant
lord
in this
may
matter.
direct the any case.
The dispute was with regard to some security.
Let it come, we'll see.
Very grateful.
Much.
I am not received to mention a matter, my lord. This is not
Original side.
appellate side, my lord. Non-commercial. Section 37 appeal, my lord.
Inclusion.
Inclusion and some preference because, my lord,
Mr. Dev, no preference. 37, what is there? 34, your 34 has been dismissed.
no. I am the claimant. I got an award. Awarded sum is 10 lakhs. It was in the year 2016. 34 filed by the appellant in 37. Dismissed.
Appellant man state.
No, not the state. It's a
Okay,
private,
private.
party. And, my lord, they are enjoying an order of stay. And previously, my lord, this matter was heard, my lord.
Stay of execution, but they've deposited the money.
Only 50% of the awarded sum. Today, my claim with the interest is 25 lakhs.
Very well, let it be listed first,
Very well,
Mr. Dev, then we'll see.
And we filed our written notes also previously, my lord, when it was heard. Kindly
Sure,
consider.
Daku, list Daku.
Grateful, my lord.
Lordship, I am in this matter. Other side.
I have
Lordship,
given notice, upon notice.
Yes.
I may-
Lordship, in this matter, I am appearing on behalf of the defendant. Lordship, I'm led by Mr. Arijit Bardhan, advocate. He is not available in Kolkata. Kindly fix the matter on Thursday. Thursday, but Tuesday, any day.
Let it be listed, sir. Hey, Daku to listed Daku.
My lord said the matter will be listed first then. Grateful, my lord.
Grateful, Lordship.
Appellate side commercial bank matter, item number 1.
Appealing for the respondent.
I appearing on behalf of the appellant, my lord. Led by my lord, learned comment reader, my lord. I'm praying for my lord. Kindly fixed any date next week, my lord. As per instruction of the my lord, learned comment reader, my lord.
Why aren't you ready, sir? The GP is a busy person, we understand.
Mr. Banerjee, my lord, Noel Banerjee, and my lord, led by Mr. Government Leader, my lord.
I will indicate in 1 minute.
So don't indicate anything, Mr. Shah. They are not going to do it today. Are they enjoying an order of stay?
That is what I am saying. And there is no order of stay. Lordship can indicate because my execution will go on. It's getting adjourned.
Very well. Accommodation, okay. Yeah. Accommodation is paid for on behalf of the state oblique appellant. Stop. Paragraph. Learned advocate for the respondent says that citing pendency of this appeal, comma, the appellant is seeking repeated adjournments in the execution proceedings. Paragraph. We clarify that pendency of this appeal will not be construed in any manner as a stay of the execution proceedings. Paragraph lists the matter. You want it?
Next week.
Next week when?
Any date before your lordship.
We list it on Tuesday.
Great.
Tuesday date to the other.
Okay.
Thank you. One more, I'm sorry. One more thing on the last occasion, supplementary paper book has been filed by them. But what I could find, the papers on the documents in that supplementary paper book was not before the trial court.
And there is no order 41 rule 27 also.
But
Then we will not look into those papers.
I just
Kindly check it up what Mr. Shah is saying. You can't just produce new documents before the appeal court.
tenders and all, but maybe with regard to the matter, but it was not there before the lower court. That's what.
Check up.
Item 2. 3. Commercial division, item number 3.
Jaggi Brothers versus Press কত?
Petro Services. 4. Item number 4. Five.
My lords, item number 5, I appear on behalf of the appellant petitioner, my lord. My lord, I have filed an application, my lord, pursuant to leave granted on earlier occasion, my lord. I filed an application being CAN 4 of 2015 seeking for amendment of plaint, my lord. The suits relates to a tender work, my lord. I have
Amendment of plaint.
amendment of plaint, my lord. My lord, what has happened, my lord? The
Have you served that application on the other
Oh.
side? Where's your affidavit of service?
my lord, Mr. Anirban Ray and Mr. Assisted by Mr.
Five.
Nilok Paul Chatterjee is appearing in this matter, my lord. My lord, very embarrassing, my lord. That is being prepared by my lord. Affidavit of service is being prepared.
Then why are you wasting time?
311.
You're not in a position to proceed in the matter.
But I have served, my lord.
How do we know that you have served?
Can I adjourn the matter for the day, my lord? I'll
Not
come back.
today.
311 দেখো হ্যাঁ এ তো কমার্শিয়াল 266311 হ্যাঁ 5টা হয়ে গেল মিটার নট টুডে হয়ে গেছে 6 আসছে না কেন কমার্শিয়াল আসছে তো item number 6
Lordship, I appear on behalf of the appellant, Lordship. It was mentioned on the last occasion, Lordship. Yesterday, we sought leave to file the appeal without the certified copies. I was being led by Mr. Joy Shah, Lordship. We have also served a copy of the stay application, Lordship, upon the respondents, Lordship.
You're appearing on whether respondent number 1 seeking for a short pass on led by Mr. Shatarup Banerjee.
Yes.
Lordship, the impugned order, Lordship, if I may.
No. So you want to do the matter very well. They're asking for a passover in the second call. In the second call.
I'm grateful, ma'am.
item number 7 item number 7 na 8 9 9 10 item 10
Sure, second call.
Item number
10, yes.
Well, I am led by Mr. Riju Ghosh. May I get a short pass?
Very well. Who are you appearing for?
The appellant.
Very well.
Respondent.
এসিডি তো কমার্শিয়াল ডিভিশনই হচ্ছে তো
Passover.
item number 2 second call item number 2 commercial division
Sandeep, usual. In the first call, nobody appeared. Oh, 22 repeat.
item number 3
Again 22. Same order.
item number 4
Na.
sorry item number 5 item number 5
Huh?
oh not today হয়ে গেছে
কি করে না
not today হয় not today হয় Not today. item number 6
Lordship, I appear on behalf of the appellant.
Yes.
No, opposing. Well, I'm taking the point of maintainability. Not an appealable order.
What is the order? Nature of the order?
Millard only time fixed. Millard
Lordship,
But
what
for
had
the
happened,
date on
if I may
24th
indicate,
of June.
Lordship,
What has happened? The order will tell us. Let us read the order.
Yes, two
Lordship, the
orders.
appellant, Lordship, there are two orders. One is 26th of March and the other one is 8th of April.
So which is the impugned order?
Lordship,
Both.
both of them. Lordship, may I just, it would be easier, Lordship. Lordship, the plaintiff,
I'm appearing for one of the respondent number IDFC Bank.
Why are you on the virtual mode?
I have some personal difficulty, Your Lordship.
Lordship, the plaintiff is the guarantor, Lordship, of the defendant number one. The plaintiff had already made over and performed his guarantee in favor of the defendant number two.
We are trying
I'm sorry.
to-
I'm sorry. I'm sorry. I'm sorry.
জাজমেন্ট গুলো এসছে, জাজমেন্ট এসছে তো হচ্ছে। ঠিক আছে,
You are the defendant.
I'm the plaintiff. I'm like being led by Mr.
I am the plaintiff. Where is the order? RBI circular.
কি অবস্থা? কাল পারবো না, কাল হচ্ছে।
You are the defendant in the suit.
One of the defendant. I am only for one.
Commercial Courts Act NH.
Yes, Mr. Shah, how you aggrieved?
The entire dispute or the entire issue, my lord, revolves around the definition of a term known as, my lord, subordinate debt. My lord, kindly bear in mind the fact that, my lord, there are two claimants against, my lord, the respondent number one company. One is, my lord, the appellant before your lordship, who is the plaintiff in the suit, and the other, my lord, is the IDFC Bank, my lord, which is, my lord, claiming a sum of rupees 24 crores. IDFC Bank, my lord, being, my lord, one of the shareholders of the defendant number one company to the extent of about 10%. So, my lord, we say it's a related party. Now, you want to do the matter? Keep quiet.
Millards.
Now, my lord, kindly bear in mind the fact that, my lord, neither the appellant plaintiff before your lordship, nor, my lord, the respondent number two, my lord, who claims that sum of rupees 25 crores, my lord, from the defendant number one company, are secured creditors. The defendant number two, respondent number two, my lord, is admittedly a subordinate debt holder.
Catalyst.
No, my lord, three. I'm sorry. Catalyst is, my lord, just the trustee. Defendant number three, my lord, IDFC Bank, my lord, is the respondent number three, my lord, is, my lord, a subordinate debt holder. So, my lord, if, my lord, a charge is registered under the Companies Act, then it becomes easy, my lord. I am the first charge holder, he is the second charge holder. So, my charge is superior to his charge. But, my lord, if both of them are unsecured creditors, then, my lord, the question that begs consideration is that whether there can be any hierarchy of payment, if at all. And whether, my lord, I can claim to be, my lord, preferential payment as against, my lord, the respondent number three.
Oh, so you are aggrieved because the learned trial court has allowed the defendant number one to continue making payment to The IDFC.
My lord, almost, small caveat. My lord, so far as IDFC is concerned, IDFC, my lord, has, my lord, to receive about between 31 to 34 lakhs of rupees per month on account of, my lord, the interest that is falling due every month. And, my lord, the loan of IDFC matures on 1st May, when they are entitled to claim the entire sum of 25 crores. So, my lord, when, my lord, IDFC, my lord, initially approached, my lord, the Learned Commercial Court and said that my installments cannot be stopped, we agreed to it, because those are, my lord, in the nature of, my lord, continuous, my lord, repayments that the company has to make in the usual course of its business. Those are, my lord, equated monthly installments, so to speak. But, my lord, when the debt is maturing, then on 1st May, my lord, IDFC, my lord, can claim the entire, my lord, principal sum of 25 crores. And that I will demonstrate to your lordship, my lord. I have to show two things to your lordship. The first thing that I have to show to your lordship, my lord, is that, my lord, a subordinate debt holder, my lord, will take, my lord, after me. That's the first thing that I have to show. Second thing, my lord, I have to show to your lordship is that they are admittedly subordinate debt holders. This is the twofold, my lord, barrier which I have to cross. In which event, my lord, it would be my submission that, my lord,
you lent money to the different number one.
My lord, I was, my lord, a debenture guarantor. So, my lord, the company, my lord, failed, my lord, to honor the debenture upon, my lord, maturity. So, my lord, I had to step in and I had to make the payment. So, my lord, three things. I filed a suit, my lord, under Order 37. I say they have not, my lord, applied for leave to defend. I say that, my lord, mine is an completely admitted claim. And, my lord, I don't really think, of course, subject to your lordship's hearing, my learned friends, I don't think, my lord, anybody is disputing, my lord, that, my lord, there is any, my lord, that, my lord, my debt, my lord, is there, and, my lord, there is a default in payment of that debt. I don't think, my lord, there is any, my lord, controversy with regard to that. And they have also made certain payments, my lord, from time to time. So, my lord, the question that really begs your lordship's kind consideration is that, my lord, on the 1st of May, whether my learned friend, by using whatever influence that he has as, my lord, 10% shareholder, I understand, my lord, that he is not a majority. But, my lord, he is a bank and he is 10% shareholder. So, he certainly, my lord, in my lord, definition, my lord, would qualify as a related party. So, my lord, using that, if he walks away with the 25 crores, then, my lord, nobody else gets paid. And, my lord, if he is a subordinate debt holder, he can't do that.
What is the paid-up capital of this company?
The paid-up capital.
Is it a company of any worth?
My lord, I am given to understand it is a company of some worth, but, my lord, it will not be able to perhaps, my lord, service, my lord, 25 crores plus, my lord, my 16 crores and other debts, my lord, that it has. So, my lord, according to the hierarchy of unsecured debts, my lord, my respectful submission is I am entitled to be paid, my lord, in, my lord, preference to my learned friend.
You prayed for an order of injunction restraining him from paying the bank, and
my lord, there are 3 orders. My lord, when I first went, and on 19th December, my lord, I got an order that, my lord, nobody would be paid unless my dues are paid. That was the first interim order that I obtained.
Ex parte.
My lord, it was not ex parte vis-a-vis, my lord, the defendant. It was ex parte. It was, my lord, at that time, and even today, IDFC, my lord, is not a party to my suit.
Obviously, my lord, I am appearing for IDFC Bank. My lord, once my learned senior makes
my lord, IDFC.
The problem is this. Problem about virtual appearance is this. You should be here present in court.
So, my lord, IDFC, of course, my lord, was not a party to my suit. So, my lord, the first order which I obtained.
If IDFC is still not a party to the suit, how are they a party respondent here?
My lord, they applied pro intereso.
Not allowed.
They applied under pro intereso.
Yes.
And, my lord, they were, my lord, heard. And, my lord, it is our respectful submission that, my lord, on basis their hearing, they were heard. 2 orders were passed after they were heard. And basis that, my lord, my lord, the learned judge appears to have said that, my lord, they are free to realize their dues. Now, my lord, in terms of that, my lord, observation, and, my lord, I have asked, my lord, categorically, my lord, I am really not concerned with them. I am concerned with third parties as a whole. Of course, I'm concerned with them also, but I'm concerned with third parties as a whole, where, my lord, I am saying, my lord, that nobody can be paid in preference to me. My lord, may I, my lord, start by showing your lordship, my lord, what is a subordinate debt? my lord, the term subordinate debt, your lordship will find it, my lord, from an RBI circular, which, my lord, your lordship will find at volume 2. My lord, it begins at 392.
Perhaps,
It
Millard,
begins at page 390.
perhaps Millard, the appeal is not maintainable because Millard doesn't come under order 43. The order passed doesn't come under order 43.
My lord, this would be under, my lord, my, my lord, may I take
I'm
that?
taking the point of maintainability. Let him first, Millard, cross
My lord,
that.
I'll answer that point of maintainability. May I just show your lordship this, my lord, and I'll answer the point of maintainability.
No,
my lord.
that is a preliminary
Very well,
point.
my lord, I'll answer the point of maintainability.
In no way will it coming under order.
Very well, my lord. Let me first, my lord, cross that hurdle. My lord, kindly, my lord, have volume 1 and kindly, my lord, take 3 orders one by one. The first is, my lord, at page 34. Page 34, 19th December. My lord, this is my application under order 39. I'm so sorry.
Yes.
My lord, this is my application under order, application under order 39, rules 1 and 2.
Page, sorry.
My lord, page 34, order dated 19th December. My lord, this is passed. My lord, if your lordship comes to page 35, if your lordship comes to page 35 and takes the second or the third paragraph there, your lordship will find, my lord, that this order of 19 December 24 is passed on my application under order 39, rules 1 and 2. Your lordship has that, my lord. Page 35, third paragraph. Additionally, the petitioner plaintiff has filed an application under order 39, rules 1 and 2 of the CPC seeking an urgent temporary injunction against R1 from alienating, creating third-party interest over its assets and properties, and from failing to deposit the claim value in security as paid in the instant suit. Plaintiff petitioner seeks relief to ensure that its right to obtain payment on the sum owed to it is not prejudiced by the defendant number 1's actions. So your lordship sees, my lord, 19 December, the court was dealing with my application under order 39, 1 and 2, which would be appealable under order 43. Now, my lord, kindly have the next order. I'm sorry, my lord, since we are on this order, kindly permit me to invite your lordship's attention, my lord, to, my lord, page 36.
Yes.
My lord, before this 19 December order, there was another order from which an appeal was preferred from the same suit. And this order refers to the order passed, my lord, in appeal by your lordships. Therefore, my lord, I am, my lord, on the basis of this order, arguing a twofold point. Number one is, my lord, that this order, which is, my lord, the precursor of the other two orders which I have, my lord, impugned before your lordship, which are also passed, my lord, really speaking, my lord, on my application under order 39, rules 1 and 2. My lord, I am first showing to your lordship that this order, my lord, is also passed under order 39, 1 and 2, which is, my lord, appealable under the Commercial Courts Act. Second, my lord, by referring to, my lord, internal page 3 of this order at page 36, I am showing to your lordship that from the same suit, in respect of an earlier order, there was, my lord, an appeal, which was entertained and orders were passed on that. I'll take it, lordship.
That is really not important. Maybe this issue was not raised. Maybe the issue of, but what you say, order 39, rule 1 and 2.
Yes.
If the order impugned has been passed on an application under 39, rule 1 and 2.
Then, my lord, it would be appealable under order 43. Now, my lord, your lordship sees, my lord, this order of 19th December. I have shown your lordship under order 39, rule 1 and 2. Kindly come to the second order, my lord, which is at page 29, which is, my lord, one of the orders against which I have approached your lordships. Now, my lord, this is your lordship will take it from the top. Today is fixed for hearing the instant intervene application filed by IDFC First Bank, as well as the injunction application. So this order, dated 26 March 2025, is also passed on my injunction application. That's number 2. Number 3, my lord, is kindly now have the second order against which, my lord, I have come before your lordship, which is, my lord, at page 31. that is, my lord, 8th April 2025. Here again, my lord, the first line.
As well as the injunction.
As well as the injunction application.
Should be all right. Yes, now subordinate.
Now, my lord, subordinate debt. Kindly have the definition, my lord, of subordinate debt. It's not there in any statute. Kindly, my lord, have page 390, volume 2, my lord.
Three nine zero,
my lord. This is, my lord, circular of the RBI. Now, my lord, I am not at present, my lord, placing, my lord, Central Bank Ravindran, which shows, my lord, RBI circulars have, my lord, statutory force. My lord, I don't think my friends will really be disputing that proposition. If at all, my lord, I am armed with it. My lord, kindly come straight away to, my lord, page 392 at the bottom, 5.1.32. 5.1.32, subordinated debt means an instrument which is fully paid up, is unsecured, and is subordinated to the claims of other creditors. So, your lordship sees, my lord, it is subordinate to the claims of other creditors. I am the other creditor. And is free from restrictive clauses and is not redeemable at the instance of the holder without the consent of the supervisory authority of the non-banking financial company. My lord, both the defendant number 1 and my lord we have non-banking financial companies.
This definition is a little funny. Subordinated debt means an instrument which is fully paid up, right,
Yes.
very well, unsecured, very well, and is subordinated to the claims. When is a subordinated debt subordinated to the claims of other creditors? That it doesn't say.
So, my lord, it would perhaps, my lord, mean that, my lord, if there are other creditors who are not claiming under this tier, subordinate debt tier, and I'll show to your lordship, my lord, that, my lord, they have been filing statements before, my lord, the commercial court, where, my lord, the statements, they themselves say, my lord, these are tier 2 subordinated debts. So, my lord, your lordship will kindly see, my lord, these usually happen. My lord, these usually happen, my lord. Again, my lord, this is a practice which is prevalent in Bombay, not so much in Calcutta. My lord, when, my lord, promoters or directors or shareholders of a company lend and advance money to their own companies or to companies in which they are substantially interested.
Where is the admission that they say that they admit that
they are 10% holders, my lord, that
that the money that they have lent
is subordinated.
It's subordinated.
Yes. That, my lord, first let me exhaust, my lord, the subordinate debt definition, and then I'll straight away go to that. These are the 2-4 things which I have to show. So, my lord, your lordship will see subordinated debt means an instrument which is fully paid up, unsecured, subordinated to the claims of other secured creditors, free from restrictive clauses, not redeemable at the instance of the holder without the consent of the supervising authority. And, my lord, the other, my lord, brief clause to which I will invite your lordship's attention is at the next page, page 393, again at the bottom, 5.1.35. Tier 2 capital for NBFCs except NBFC BL is the sum of, then, my lord, kindly see Roman 5, subordinated debt. So, my lord, these are subordinated debts, my lord, are tier 2 capital, my lord, are all subordinated debts. All tier 2 capitals, my lord, of NBFCs are subordinate debts. Now, my lord, now, my lord, having shown your lordship, my lord, this aspect of the matter, kindly, my lord, now have page 386. This is, my lord, the same, my lord, I showed you 390 just up, my lord, before that. Just before that. My lord, at 386, your lordships, my lord, have, my lord, the sanction letter by which, my lord, your lordship will see on the top, Capital First. Capital First has become, my lord, IDFC Bank. capital. Now, my lord, kindly see 19th April 2018. Kindly see subject. Sanction letter for subordinated unsecured term loan of 25 crores. Your lordship has that, my lord. So in the subject itself, it is written sanction letter for unsubordinated unsecured term loan. Then, my lord, kindly come to, my lord, the table. Kindly see facility, subordinated unsecured term loan. Then, my lord, below that facility amount is 25 crores. Below that, my lord, principal schedule repayment, door to door 84 months loan. Principal shall be paid on the first day of 84th month from the first disbursement. So, my lord, this
Capital First Limited
has become IDFC
FC Bank.
Yes.
Oh, that's what I'm asking.
Yes, it's become. That's admitted. It's written in the order itself.
Okay.
So, my lord, in 2018, when they advanced this loan, the caption itself says it's a subordinate debt. And, my lord, in the table, it is clearly stated subordinated unsecured term loan. Then, my lord, rate of interest is specified 14.25. And, my lord, 84 monthly loan. So, my lord, the interest was being serviced, my lord, and this is what we had no objection to. That, my lord, the monthly payment of interest, my lord, because, my lord, that would, my lord, continue, my lord, in the, but otherwise, my lord, it would mean, my lord, loans taken from anybody can't be serviced.
That is what has been allowed by the trial court.
My lord, what has been allowed by the trial court, my lord, was initially, my lord, my order passed, my lord, in my favor was modified. And, my lord, it was stated that, my lord, the initial, the installments can be paid. Then, my lord, on the returnable date, when I said that the installments can be paid, but please clarify that the principal sum cannot be repaid. There, my lord, the court says there's no need to clarify it. And, my lord, it may be paid. So, my lord, there are related parties.
You want that clarification?
Just, my lord, I want that clarification. In the meantime, my lord, really speaking, my lord, my submission is that this issue of unsubordinated debt is noticed by the court, but not decided. So, my lord, till such time that it is decided, my lord, your lordships can, of course, decide it. And, my lord, that would be my request to your lordships also. But, my lord, till such time that it is decided, if they, my lord, walk away with the 25 crores, my suit becomes, my lord, completely, my lord, odious. So, my lord, two documents I want to show, my lord, that they admit that this is, my lord, an unsecured debt. Subordinate debt. I'm so sorry, my lord. So, my lord, the first is from the sanction letter itself. Secondly, my lord, kindly have statement.
Page 409.
Yes.
Volume 3.
My lord, kindly have also, my lord, page volume 3, page 409. My lord, these are the statements
Pursuant to the direction of the division bench.
I was inviting attention to 409.
Yes.
My lord, these are statements filed, my lord, by them, by my lord IDFC Bank. IDFC Bank, ASA. By my lord, the R1 company. I'm sorry, my lord. R1 company, the borrower company. My lord, before my lord, the learned commercial court. Kindly see, my lord, your lordship has page 409, borrowing as on 31st December. Now, my lord, under my lord, the first category, kindly see bank stroke FI. My lord, your lordship will find, my lord, my name, Northern Arc. I am, my lord, the plaintiff appellant before your lordship. So, my lord, my debt is not subordinated to anybody else. Then, my lord, your lordship will kindly see ECB, and then, my lord, sub debt tier 2. My lord, I've already shown your lordship, my lord, in my lord, the RBI circular, the second portion which I showed, that, my lord, all tier 2 debts are subordinated debts. So your lordship is seeing here sub debt tier 2, that is, my lord, Capital First, IDFC Bank, IDFC First Bank Limited. So, my lord, my lord, really speaking, my lord, I don't think, my lord, there is any controversy that there is a subordinated debt. It is with regard to, my lord, what is the out of, my lord, the debt being a subordinated debt. Now, my lord, permit me to show your lordship how this question has not been, my lord, either addressed or answered really by my lord.
It has not been addressed. We have gone through the orders.
It's not been addressed at all. So, my lord, my my lord, simple request to your lordship is this, my lord, that, my lord, ultimately, my lord, if, my lord, on the 1st of May, when, my lord, this amount matures for payment, my lord, may I just show your lordship one more thing? My lord, permit me to just show your lordship that they are, my lord, 10% shareholders. My lord, your lordship will kindly have, my lord, volume 3, page 568. My lord, I'm sorry, I made a mistake. They are not 10%, my lord, they are 9.98%. My lord, that your lordship finds at 568.
Yes, yes.
This is the shareholding pattern. They are at, my lord, item number 2. So, my lord, your lordship will see ASA International Holding, which is the holding company of ASA International Microfinance. That owns 90%, and, my lord, the remaining, my lord, is owned by, my lord, IDFC Bank. So, my lord, they are a related party. My lord, under the, my lord, IBC, of course, my lord, related party, you only need, my lord, 2%. In some cases, my lord, more than that, but usually, my lord, 2%. So, my lord, they are in a position, my lord, to, my lord, influence.
IDFC First Bank Limited. Correct. IDFC Bank. There's another IDFC Bank, isn't it? Or this is the one?
This is the one I think Amitabh Bachchan advertises for.
That hardly answers the question, you know.
It occurred, the same thing occurred to me, my lord, by so he said, no, this is different.
Anyway, yes, this is.
So, my lord, this is, my lord, my lord, request to your lordship, my lord, kindly see, my lord, the impugned order now once, my lord, and then, my lord, I'll take my seat. My lord, kindly, my lord, first have, my lord, the order at page 29, 26th March. The ordering portion, my lord, is at page 30. Or, my lord, page 29 at the bottom. This is, my lord, the order of 26th March. After hearing learned advocates for all the respective parties, as well as the intervener, it appears that the defendant respondent should continue to pay loan installments, if any, by EMI or otherwise till the next date. This order is made for the ends of justice in the light of the order passed by the Honorable High Court, dated 17th January 2025, passed in FMA number so and so. Accordingly, it is observed and ordered that till the disposal of the injunction petition, as well as IA number so and so, there is no restriction or restraining order upon the defendant to pay the EMI loan installment, if any, to the intervener till the next date. Now, my lord, this, my lord, we had not really opposed. Because, my lord, like I told your lordship, we were not interested in stopping, my lord, the monthly installments that were being paid. But, my lord, then we realized, my lord, that the main amount falls due in May. And, my lord, when your lordship put the question to me yesterday, that, my lord, why was there, my lord, a small gap, my lord, between 26 March and coming to your lordships? It is because, my lord, thereafter, my lord, because initially, my lord, this order, my lord, there was no problem at all. We just wanted to prevent, my lord, the 25 crore, my lord, payout at a time, which would mean, my lord, that nobody else would be paid. Now, my lord, Kindly have the next order at page 31. This is the second order. I have, my lord, paid, my lord, 2 court fees, so that, my lord, I can.
This IDFC First is a private bank.
It's a private bank, my lord.
Isn't there a government bank, IDFC?
My lord, that it's not government, my lord. It's like HDFC and all the others. They are all Section 8.
IDBI.
IDBI. They are all, my lord, Section 8 companies. The second order, my lord, at page 31, 8th April 2025. Kindly again come, my lord, to the operative portion. My lord, from, my lord, page 32. My lord, page 32 top, my lord, may I take your lordship? Or, my lord, page 31, last line. Learned advocate for the plaintiffs has contended that the order number 11 dated 26 March 2025 be modified to the extent that the quantum of EMI loan installment in the said order may be specified within the band of 31 lakhs to 35 lakhs and not more, so that it does not become a prop for the intervener to recover the alleged sum of 25 crores in a bulk as installment. So, my lord, that was, my lord, our prayer that please modify that order so that they can't lean upon this order to say that we've been directed to make payment. Then, my lord, kindly, my lord, skip the next paragraph and come to the paragraph after that. There was hot exchange between two sides. Plaintiff alleged intervener pro inter so is a shareholder of the defendant number 1 bank, and he has intervened in a motivated manner in order to deprive the plaintiff from his dues. Then, my lord, the next paragraph, if I may, my lord, read, my lord, from the middle of that next paragraph. Or, my lord, may I read it from the top? On the other hand, learned advocate for the pro interest suo submitted that merely holding 10% of the defendant number 1 company does not make the pro interest suo an owner of the company. So they admit, my lord, that they are 10%. He is not favoring the defendant number 1 and is neither sailing in the same boat with him. The defendant number 1 owes him 25 crores. He is interested to ensure that his dues from the defendant number 1 are not wiped out and that no preference is given to the plaintiff in the manner of debts owed, as the plaintiff and the pro interest suo are unsecured creditors and the plaintiff is not in a superior position in the matter of realization of debt from the defendant number 1. So, my lord, this issue is squarely raised, but, my lord, thereafter not answered.
You have also borrowed money from the bank.
No, my lord, I, my lord, guaranteed, my lord, a debenture series. My lord, they have not paid. The defendant number 1 has not paid. I had to pay, and so I, my lord, by subrogation, my lord, I have.
They submitted before the trial court that they have lent money to you also.
My lord,
yes, the last sentence of that paragraph you were reading.
Yes, I'm sorry, my lord. The pro interest association and lump sum money even to the plaintiff. Oh, maybe, my lord, I don't know, but that is, but that same is part of different dealing. I don't know. That it may be, my lord. I'm sorry, my lord, I did not notice this portion, my lord.
Yes.
Thereafter, learned advocate for the plaintiff made his submission before the court, pressing for judgment in the instant suit, my lord, because we had filed under Order 37 of the CPC as the defendant had not taken leave to defend within 10 days.
Yes.
Now, my lord, kindly come, my lord, to, my lord, page 33. My lord, the third paragraph again. As the intervener pro interest suo has prayed for extension of the interim order and extension of the same is required to be granted pending contested hearing of the application filed by the intervener pro interest suo. No quantification of the EMI loan installment is necessary at this stage. This is, my lord, the portion I'm aggrieved by. There is no embargo for the intervener pro interest suo to realize the debt owed to him, taking recourse to the due process of law by independent suit or otherwise. So, my lord, the money can be paid. At it now, my lord, it appears to have, my lord, the blessings of the court. So, my lord, this is, my lord, the limited, my lord, remit of my lord appeal before your lordship. My lord, there must, my lord, be a finding, my lord, respectfully, with regard to, my lord,
subordinated
as his, my lord, status as a subordinate debt holder. My lord, these are my respectful. My lord, only one thing, my lord, I was wondering. মাইলট মে একটা কপি আমাকে এটা দিন জজ সাহেব এইটা দিয়ে দিন একটা বই এই আদের সাইডকে কপি কোনটা মাইলট বেঞ্জামিন অন ফিনান্সিয়াল ল paragraph 16.54
unless and until the claims of other creditors can be made.
What is the EMI that is presently being paid by them to the bank?
between 31 to 34
Is that correct?
lakhs. 35 to 35.
I'm supposed to service
Around 35 lakhs.
It's around 35 lakhs.
But Malad, I understand, Malad, that the period of interest is over. Because Malad, the last
That's all
interest
right.
was 84
What
months.
we had in mind, Mr. Banerjee, and Mr. Counsel for Mr. Bagh,
My lords.
we'll remand it with a time-bound direction to decide this question first. Till then, the EMI will continue and no more. 3 months. Decide the question first. You go on paying the EMI at 35 or 36, whatever it is. And depending on what the decision is on the issue of subordinated debt.
The only thing is that, my lord, this, my lord, servicing that I'm doing pursuant to a division bench order of this court.
We are not stopping it.
So, my lord, the quantum, my lord, is according to the agreements that they all have with me.
What you are paying now, go on paying.
Yes.
But for the next 3 months, don't pay more till, and we'll say within.
There is, my lord, I don't know. There is a subsequent order which has been passed by the learned court below, which perhaps, my lord, lordship needs to look into, where all the matters have been fixed for hearing. That order, my lord, perhaps
We will not ask for any adjournment.
Kindly takes page 55. Kindly takes page 55 once. This is the last order of the learned court below, my lord. 9th of April 2025. Lord, kindly sees the order. Today, the matter is fixed for under Order 37, Rule 36 of the CPC, along with injunction application and pro inter se suo application. So, my lord, he has not been added as a party as yet. Although I don't know, my lord, how he is made a party to the appeal. And DCF in respect of the written objection filed by the defendant number 1. The learned advocate for the plaintiff appears and files Hajira along with an affidavit in reply to the written objection filed by the defendant number 1 in IA such and such. Well, this was directed by this honorable court by the division bench order. Copy served an objection raised by the learned advocate for defendant number 1. The learned advocate for the defendant number 1 appears and files Hajira along with deficit court fees of ₹10, compliance with order dated 8/4/2025. The learned advocate for the defendant number 1 also files. This leave was granted to us by the division bench of this honorable court because they had not taken, my lord, a 12-way dispensation for filing a commercial suit. So I've taken the point of maintainability there. So this leave was granted, files a revocation application under section 151 along with annexures. Learned advocate for the intervener pro inter se suo appears and files Hajira along with extension petition without court fees supported by affidavit praying for extension of ad interim order which stood in force till today. Now, my lord, kindly sees heard the advocates for the respective parties 24/6/2025 for hearing revocation application. So the suit itself is questionable because, my lord, we had demonstrated before this honorable court that a commercial suit is being filed behind the back without dispensation of 12-way. Now, my lord, kindly sees dated 9/4/2025 with injunction application and pro inter se suo application. So he's still not added as a party. And all of these, my lord, along with his application under Order 37, Rule 36, in respect of extension application, my lord, on 24th of June 2025. So all these matters are coming up for consideration. This order is not under challenge before, my lord. So, my lord, therefore, the trial court has not, my lord, passed any orders as yet. 4 applications are coming up for hearing. This should have been shown to my lord.
Mr. Shah,
My lord, I
today
will
this
not-
order
Yes.
of 9th is not under challenge. By that, the interim order has been extended.
My lord, the interim order has been extended. My lord, I am, my lord, challenging the interim order itself. My lord, it could have been challenged, my lord. Your lordship will, my lord.
Should have been.
It should have been challenged. It should have
Absolutely.
been challenged.
File a separate appeal if you like.
And these are all
My lord,
coming up on
my lord, I'll tell you,
24th.
lordship. My lord, kindly, my lord, keep it, my lord, tomorrow, my lord, my lord, amend it. But my lord, kindly permit me to, my lord, make this point. First of all, my lord, let me answer this. My lord, kindly come to page, my lord, 36.
I'll make my submissions, my lord, once you finish.
Kindly come to page 36. Considering the
Shah,
fact,
these are all interim orders, and the last interim order, with which really, in a sense, the other interim orders merge, you have not challenged. Simple point.
yes, my lord, may I answer?
No one stops you from challenging.
My lord, may I answer that, my lord? My lord, it's true it has merged, but my lord, if the parent order goes, if the parent
order is no more there,
my lord, the other order, my lord, I tell you, lordship, it's just, my lord, my lord, I would have understood that there is any addition to the order.
Why don't you file an appeal?
My lord, I'll do that, but my lord, first is, my lord, the disbursal.
Today is what,
9th.
29th, you have the rest of the week.
No, my lord.
Yes.
Tomorrow, 30th and then 1st. My lord, otherwise I would have, my lord, it doesn't take much to file an appeal, my lord.
This order wasn't drawn to your attention, we are sure.
Yes, my lord, it should have been, my lord, included, my lord. I should have paid another. My lord, your lordship can.
Not today, do what you can.
My lord, your lordship can entertain, my lord, my oral prayer. My lord, I am, my lord, seeking leave to, my lord, add, and I'll put in, my lord, the deficit court fee, my lord, of one court fee. I'll do that, my lord. I'll challenge this as well. But, my lord, kindly, my lord, appreciate.
A two-page appeal today, in the next 1 hour, ask your junior. It will be listed tomorrow.
Very good.
Numberটা দিলে list করে দিও.
Very good. I'm deeply blessed.
Milord, I apologize for appearing virtually, Milord. Tomorrow, definitely, Milord, I'll be physically present. Milord, I'll indicate in 10 minutes what my learned friend has submitted.
May I take my lord's leave, my lord? Grateful.
I'm deeply obliged, Milord.
Grateful. Justice Shonji Banerjee used to use the term bulla-carted, which was the English version of Gorur Gadi Chapa.
Gorur Gadi Chapa, exactly. Exactly that.
I'm reminded, my lord, of that small phrase.
What's the English term?
Bulla-carted.
Bulla-carted.
Grateful.
Item number 10.
Item number?
10.
Oh.
Passed over matter, my lord. I am for the award holder, my lord. Mr.
Passed over, man?
It passed.
This is the second call, huh?
I'm sorry.
Your 34 was dismissed.
34? Yes, my lord. 34 before the commercial court, and thereafter, my lord, the appeal here. My lord, the point, my lord, was non-service, my lord, of the summons while the arbitration, my lord, was on. My lord, your lordship will find that the notice of arbitration was not even served upon us. We filed an application before the learned arbitrator saying that, we have not even been served with the notice of arbitration, so we were not in a position to participate in the arbitration. That application, my lord, was taken up on the 23rd, rejected on that particular day, and the award was published, my lord, after the Saturday and Sunday which intervened. We went
You have secured the amount?
Yes. Then
Bank guarantee?
Yes, my lord. And then there was, my lord, even when this appeal was first heard by the Honorable Division Bench presided over by Justice Sen, my lord, we were allowed to inspect, my lord, the trial court, the arbitration arbitrator's records. My lord, we can show from those documents itself, my lord, that we were never served, my lord, in the address, my lord, which was we were to be served. Never. Just the award, though, was served in the correct address. This shows, my lord, the malafide. Every notice, my lord, we'll show your lordship from the records because this is not there with us here. Every notice was served in some other address, but the award, my lord, very nicely has been served on the correct address. And this is the point, my lord, for your lordship's consideration. The section 34 court said that since it's 34, I can't look into it. This is what it is. Nothing beyond. And the crux of the matter was that when the matter was initially সেটা তো মেরিটে গিয়ে বলতে
To us.
Initially, my lord, Justice Sen, my lord, the Honorable Division Bench of Justice presided over Justice Sen said, gave a proposal to my learned friend that we set aside this, send it back to the arbitrator, and within a period of time, it can be heard of. Mr. Ghoshal, I don't know whether he has instructions to that effect, then this will obviate a lot of things.
Things, Millet. First of all, Millet, I would like to take instructions on this, Millet. But on the last occasion, Lordship will kindly take one order.
Mr. Ghoshal.
Yes, Millet.
Mr. Chatterjee sounds very confident that he'll demonstrate that the notice of arbitration or other notices was sent to address X.
Yes, that's his
and the
case,
award
yes.
was sent to address Y, which is the correct address. So if he is able to demonstrate that, it will definitely come within section 34, breach of natural justice.
Absolutely.
So therefore, please take instruction.
We will, Millet. We will. One thing, Millet.
Yes.
Lordship will kindly take the order of 6th of March 2028, Millet. 2024, Millet. 2025, Millet. I'm futuristic. I'm sorry. Well, I'm sorry, Millet. In this order, Millet, the Honorable Division Bench, Millet, a coordinate bench, Millet, had directed the department to produce the records of AP 279 of 2018, Millet.
Yes.
Original record. We do not know, Millet, whether those records have already been, Millet, produced, Millet.
সাথে আছে আছে আমরা দেখেছি
Have you taken instructions? But Lordship will kindly keep it on Thursday, Millet.
Also, the original record of the arbitration proceedings.
Yes, yes.
এগুলো এসে গেছে?
পেপার বইটা নাকি এলসিআরটা যেটা ওই অন্য প্রসিডিং যেটা ছিল না অর্ডারটা দে না সাহেব আই এম সরি ওই ফাইলটা তলারটা হ্যাঁ হ্যাঁ
ওখানে সার্ভিস ঠিকঠাক হয়েছে
ওই রেকর্ডটা দেখতে চাই
Lordship will, for convenience, Millet, Thursday, keep it on Thursday, Millet. In the meantime, Millet,
Day after tomorrow.
Day after tomorrow, Millet. অসুবিধা নেই তো?
না
In the meantime, Lordship will pass a one-liner that we will come and take physical inspection of the court records, Millet.
Yes, sure. This appeal is directed against an order of the learned trial court dismissing the appellant's application under section 34 of the Arbitration and Conciliation Act, 1996.
Provided
paragraph
entering into license agreement. এই দুটো document.
As requested by learned advocate for the respondent, let this matter be listed again on Porshudini date thou, when he will come back with better instructions.
First
paragraph. Parties will be at learned advocates for the parties will be at liberty to inspect the court records.
And Millet, the suggestion that was Millet advanced.
Should we record that? Should we
No,
record
Millet, the suggestion I will also take instructions with regard to that. What Mr. Chatterjee has.
That's right. That is the only thing.
My lord records it.
Should we record that?
On the last occasion. Yes, yes.
I think help you. Also.
Yes, yes. The suggestion was made was advanced from the bench, Millet, and I also agreed to it and asked for instructions, Millet. Let me also take instructions on that aspect as well, Millet.
main ground on which the award has been challenged, the arbitral award has been challenged, is that no notice of the arbitration was served on the appellant herein. Stop. The entire process is vitiated by breach of the principles of natural justice. Stop. The paragraph. Mr. Chatterjee, learned senior counsel, appearing for the appellant, suggests that to expedite things, the matter may be remanded to fresh arbitration and the time-bound program may be set. Stop. Two, not remanded for fresh arbitration. Paragraph, Mr. Ghoshal, learned senior counsel representing the respondent, says that he'll come back with appropriate instructions on that score. This is the matter to boli diyechi.
So grateful.
Hey, হয়ে গেল কমার্শিয়াল
Two six six 301. Item number 1, non-commercial affiliate side. Don't need. 2.
May it please your lordship, Millet. Restoration, the section 5 application, Millet. 81 days delay.
Unfortunately, I am opposing, Millet.
Or under
Section 5.
Section 5.
Section 5 and restoration. Millet, kindly see, this is an
Very well.
challenge to the award. Award is of 2009. 2009. Today, Millet, and the appeal has been filed in 2012.
No, 34 was filed when?
34 dismissed in 2009.
34 dismissed in
2009. 2012, the appeal was preferred. After 3 years, delay was condoned at that point of time. From 2012 to 2025, the matter appeared in the list, state did not appear. Ultimately, by the order by which the Honorable Division Bench dismissed the appeal, it is recorded that appellant did not appear on several occasions. Even today, it is not there. Award holder is represented and the appeal has been dismissed.
Our order, no?
No, the previous division bench. 6 lakhs. So, my lord.
File affidavit.
That is why, my lord. Otherwise, my lord.
Yes. The execution is
stated Dushtu. I tell you.
Lord, may I make one?
Yes, please.
My lord, their execution was also dismissed, my lord. We did not oppose this.
No. Execute. I tell you, lord.
They should be not quit. They should also not oppose our.
Stayed, because when the appeal was pending, the money was deposited, execution was stayed. I naturally did not watch the list.
So dismissed for default.
So matter
has been
appeared, got
restored.
dismissed for default. After this appeal was dismissed, I had to take out a restoration. So it is not a grace of my learned friend.
Millet, there is a bank guarantee which has been furnished by us, and that is being deposited before the registration. We have.
Mr. Chingupto, Mr. Sen's on instruction wants to file an affidavit. How can we stop that?
No, but only thing is that the execution case is pending on the 2nd March. That's a whole difficult 2nd May, Millet.
Execution
If your lordship kindly take trouble to see the order dated 22nd July 2013. Kindly have a look into that, Miller.
No, nothing today. Hey, issue. Which is the condonation? Can
Miller 4 Can 5.
Can 5 te order ta koro. This is an application for condonation of delay of 81 days in presenting the restoration application. Stop. The appeal was dismissed when? For default. Dismissed for default on December 17, 2024. Paragraph. Learned senior counsel appearing for the respondent, on instruction, prays for leave to file an affidavit in opposition to the condonation application. Stop. He says that normally he would not have opposed the application. Stop. However, the facts of this case would demonstrate the indolence on the part of the state. Stop. The paragraph, learned senior counsel says that the state's application under Section 34 of the Arbitration and Conciliation Act, 1996, for setting aside the arbitral award, was dismissed way back in 2009. Stop. In 2012, an appeal was preferred after being granted, after the delay being condoned by this court. Stop. From 2012, the state took no steps for hearing of the appeal. Stop. Ultimately, in December 2024, the appeal was dismissed for default. Stop. Paragraph. Let affidavit in opposition be filed within a week from date. Stop. Reply thereto, if any, be filed within a week thereafter. Paragraph lists the matter 2 weeks hence.
May kindly record that we have already deposited the 55 lakhs before the Register General.
That is the award amount.
Yes.
Principal amount.
Principal amount.
There is no dispute.
Mr. Sener submission report.
Because otherwise, Miller, they will.
Mr. Sengupto, learned advocate representing the state, capital S, says that there was no latches on the part of the state. Stop. The respondent also took no steps for hearing of the appeal. Stop. The state has secured the entire award amount of rupees 55 lakh.
96,844.
55,96,844 by depositing the same.
Principal amount before the register, and there is a condition that once we deposit the same, Miller, the stay will continue until the disposal of the Miller, the application and the appeal.
So appeal is not there.
You will learn by depositing the same with the Registrar General.
Registrar General, Miller.
Registrar General of this court. Just record Quran out.
Nowadays, my lord, the position of law is now, my lord, even if the amount is secured, the award holder, in order to enjoy the fruits of the award, is entitled to obtain release and give a guarantee.
That has been reflected over here.
Why don't you do that?
That
is reflecting over here.
If it comments to your lordship, my lord, not counter guarantee, my lord, I will affirm an affidavit of undertaking. If the succeeds, I will deposit.
Affidavit of undertaking has no value, Mr. Sen.
No.
Today, you, on the basis of such an affidavit, you withdraw the money. You're a company.
Yes.
Tomorrow, you go into winding up.
Partnership
And they win the appeal.
There is nothing left.
Individual directors will.
There is a.
Anyway, without any application, we will not consider that. 1 week, 2 weeks.
Well, I don't want an order, but they should come and proceed
with the execution. That's it.
Go out of the court with a smiling face, request Mr. Sense. There are two sense here. So sense and sensibility.
Also, will not offer me
cup of coffee.
Some lozenges which I carry.
Brazilian coffee or Darjeeling tea?
Darjeeling. I am fond of that.
Very good.
Item number 3.
May it please your lordship. Well, this is my appeal under Section 37 of the Arbitration Conciliation Act, my lord, from the order setting aside an award under Section 34, my lord. I'm the award holder. My lord, I'm an MSME. And I had obtained an award from the Facilitation Council, my lord, that was assailed by the respondent in Section 34 proceedings, and it has been set aside. My lord, my appeal is from that award. But however, my lord, I have two applications, my lord. There is a condonation of delay, my lord. There's a delay of 11 days. Lord, I have served a copy of my application upon the respondent, my lord.
No, Section 5 has not been served upon me.
Section 5 not served? You have the affidavit of service. My lord, we have an affidavit of service, my lord, for Section 5.
Service.
My lord, there are two applications. Can 1 and Can 2, both has been served, my lord.
I'm sorry, my lord, it has been served.
My lord,
upon
they
us.
have it. এটা দিলে তো? হ্যাঁ, ওই দুটো। My lord, she has got it.
Lordship.
Item delivered, addressee.
Yes, Lordship. I have the.
You've got it?
Yes, Lordship.
What do you say, 11 days delay?
My lord,
Nah,
10th
you can't
February.
oppose 11 days delay.
10th February, my lord, impugned award.
Hey,
was passed.
which can is that?
My lord, Can 2, my lord.
Can total করে দাও causes shown here. This is an application for causes shown being sufficient. Can 2 disposed of. Then Can 1. Can 1
My
is
lord,
the
Can
stay.
1, my lord, is my stay petition, my lord.
Now, where's the question of stay? Appeal has to be heard out.
My lord, I agree, my lord. My lord, the only difficulty, my lord, here is, my lord, I have made an adventurous prayer, my lord. I shall happily submit.
Really?
My lord, they have,
Just for entertainment, let
Yeah.
us see the prayer.
my lord, Section 34, my lord, was initiated without payment of the mandatory deposit of 75% of the arbitral award. If lordship comes to the impugned award, my lord, impugned order, my lord, it
And
starts
the
at page.
court permitted that.
My lord, that is not permissible, my lord, under the MSME Act. Lord, it is the apps.
You want them to deposit now?
Yes, my lord.
When there is no award at all?
My lord, my lord, I cannot proceed with my execution, my lord. The execution proceedings have gone.
No, no. Are all papers here?
My lord, everything is here, my lord.
Everything is here. Then
Then
we'll
that
hear out the
event-
appeal.
Lordship.
Hear out the appeal itself.
Lordship kindly allows us to file our affidavit in opposition to their application.
Why?
No, everything
We'll
is on
dispose of
record.
the application. We'll
My
hear
lord,
out the
it is entirely on point of law.
Yes, we'll hear out the appeal.
On facts, my lord, they have nothing to say, neither do I.
একটা লেখো এবার can 1টা নাও. This is an application for stay of operation of the order impugned in this appeal, comma, whereby an arbitral award that was made and published in favor of the appellant herein, comma, was set aside. Stop. We wish to hear out the appeal. Stop. We are told that all papers that were available before the learned single judge
Yes, ma'am.
have been annexed to the stay petition.
All pleadings, my lord. All pleadings are annexed.
All papers.
Yes.
Stop. Let the stay petition be treated as an informal paper book. Stop. All formalities are dispensed with. Stop. Since the respondent is represented, comma, notice of appeal is deemed to have been waived. The stay application stands disposed of. এই রেকর্ডটা দিও না কারণ এটা এইগুলো থেকে এইখান থেকেই আমাদের এটা হবে রেকর্ডটা পাঠিয়ে দিও না কিন্তু প্যারাগ্রাফ when do you wish to argue the appeal?
My lord, any day, lordship.
We can hear it
I am
today
ready
also.
today also, my lord.
Mr. Banerjee, when do you want us to take up the appeal?
Any day after Millard 7th, subject to, of course,
After 7th.
After 7th Millard of the next
Yes,
month.
very well. The application dispose of করে দিয়ে next let the appeal be listed for hearing. 8th?
Yes, my lord.
9th is a holiday, yes.
9th is a holiday.
8th, my lord, is a Thursday.
Yes. Good day for you. Only thing, ensure it's before 12 o'clock.
My lord, if
After that is Barbella.
My lord, will the hearing matters will retain its position in the list in a place where it will be taken up, lordship? Because my lord,
Let us
just a
see.
humble request.
8th is another day. Who knows what will happen?
Grateful, my lord.
স্টেটে ডিসপোজ অফ করে দাও কিন্তু কাগজগুলো যেন পাওয়া যায়।
My lord, very interesting questions of law are there, my lord, which lordships will have to decide.
Very good.
Decision is Decision, my lord, is pending. It has been referred to the larger bench as well, my lord, which I've discovered only today morning before the Supreme Court. My lord, one of the issues, but lordship, that has been left, the Honorable Division Bench of Supreme Court has made up its mind on this issue.
What is the point?
My lord, point is whether, my lord, the supplier under the MSME Act, my lord, whether that registration under the Section 8 of the MSME Act is necessary for a supplier to come and avail the benefit of the arbitration under the MSME. That is my sole point. The other 2 points, my lord, is on the face of it, my lord, will appreciate that it has to be set aside. But this is the only question which my lords will have to dwell upon and pass a judgment on that. The interpretation laid by the learned single judge
What has been held?
the learned single judge has held, my lord, there has to be a registration, compulsory registration under the MSME Act under Section 8. And we, although in our case, my lord, we already have a prior registration before a different authority, which was under the previous legislations. So the MSME has held that a prior registration is adequate, reading into the provisions of the MSME Act. However, the learned single judge has held that Section 2, the definition clause Section 2(9), that has to be given a restrictive interpretation, which, my lord, contradicts with the concept of a welfare legislation that should be given a more liberal interpretation.
Very well. Very well.
Grateful, my lord.
Come back.
Grateful.
Item 4.
I beg to appeal for the appellant. The evidence service.
Yes, my lord, I think that this is not an appealable order, madam. The order under challenge is not an appealable order. Order is an order referring the parties to arbitration, my lord. Which one appeal, my lord?
Section 11.
Referring the no, my
It was a suit, my lord.
Section 8. Section 8 applicable.
Section 37(1).
Yes, it is appealable.
But it's not appealable.
Wait, देखिए arbitration act दाओ.
Extra copies of it.
Curry dismissal appealable.
Well, I had one question.
Yes, sir. Appealable? How appealable?
That is what I'm thinking, my lord.
Not. It makes section 37(1)(a) says
We'll just have a
order
look.
refusing to refer is appealable.
I understand that, my lord.
Allowing is not. SLP. Your only avenue is SLP. That is always there.
It's a civil court order, my lord.
Civil revision.
Civil revision. One scope here in this court.
SLP lies from any order of any forum.
That will be too, my lord, too costly for my client.
So what you want to withdraw?
Withdraw fresh. Liberty to withdraw and file.
Oh, sorry, two. अभी okay टाकी क्यों नहीं आई ना? This appeal is directed against an order of the learned trial court referring the parties to arbitration under Section 8 of the Arbitration and Conciliation Act, 1996. Stop. Paragraph, learned advocate for the respondent takes a preliminary point of maintainability of the appeal. Stop. She is right. Stop. The appeal is not maintainable under Section 37 of the 1996 Act. Stop. It is only an order refusing to refer the parties to arbitration under Section 8, which has been made appealable. Stop. Paragraph. At this juncture, learned advocate for the appellant seeks leave to withdraw this appeal with liberty to pursue any other remedy that may be available to the appellant in law. Paragraph. Such leave is granted. Stop. The appeal and the connected application are dismissed. Stop. This will not prevent the appellant from taking recourse to any other remedy that may be available to her under the law. Stop. Paragraph. Let the certified copy of the order of the learned trial court be returned to learned advocate on record for the appellant upon a true copy of the same being furnished for being kept on record.
Photocopy.
True
photocopy.
Photocopy. True copy, not a photocopy.
Briefly.
Item 5.
Item number 5, Lordship, I am appearing for the appellant, Lordship. By an order dated 22nd of April, your Lordship was pleased to direct to serve a notice upon the learned advocate representing the respondents. I have tried to communicate that, but she has communicated that she's not appearing in this matter anymore. So she'll not appear in this matter. So for this reason, we have also served her through WhatsApp also, your Lordship.
Serve the party.
Your Lordship, the only thing is that we have also tried to serve the party. There was a direction of your Lordship. Lordship kindly sees the order dated 22nd of April. We have served the learned advocate representing the party. The only thing is that the learned advocate representing the party has said that she is no more appearing in this
We have
matter.
understood that.
Yes,
Then
yes,
what
yes.
is to be done? You tell us. What kind of order we can pass?
The only thing is, Lordship, the matter has to be referred to arbitration, Lordship. This is a 5 and 8 application which has to be rejected, your Lordship.
This is Section 8 application.
Yes. The learned trial court has refused to refer the matter to arbitration. And your Lordship kindly sees the order dated 6th of March once. There was an interim order of deposit, which they have not given. And time and again, I have been instructed that my agents are trying to contact him by phone. He has said that he will not pay a single amount. Single penny.
6th of March.
Yes.
কোথায় বাবা এখানে তো কোনো 6 মাসের order পাচ্ছি না।
There was an order dated.
There was, because we recorded that in our
Yes.
22nd April.
Yes, where the
কোথায় ফাইলে
order of
নেই কেন
deposit
6
was
মাসের order আছে তো? অর্ধেক order পাওয়া যায় না। দেখো 6 মাসের order কোথায়? দুটোই পেয়েছো? বড় দুষ্টুমি করছে। তাই করি আমি। এটা এসো দেবজ্যোতি। Read orders dated March 6, 2025 and April 22, 2025. Paragraph. By the order dated March 6, 2025, a coordinate bench had observed that prima facie there appears to be an arbitration agreement between the parties. Stop. However, the learned single judge has dismissed the application under sections 5 and 8 of the 1996 Act. learned single judge বললাম না, learned
Lordship, learned judge 6.
learned trial court বলো, trial judge, learned trial judge, হ্যাঁ আচ্ছা paragraph. Considering the fact that the vehicle is still in the possession of the respondent, comma, the coordinate bench directed the respondent to pay a sum of rupees 1.75 lakh to the appellant within 3 weeks from the date of that order without prejudice to the rights and contentions of the parties. Stop. Oh, Mrs. Geetoshri Mistry is no more appearing.
No, she is no more appearing. She has refused to serve, and without any endorsement, we have served her by WhatsApp also and intimated the date that today.
Paragraph. By our order dated April 22, 2025, we had directed learned advocate for the respondent, for the appellant, to communicate to learned advocate for the respondent that this matter will be listed again on April 29, 2025. Paragraph. Today, learned advocate for the appellant tells us that the respondent's learned advocate has told him that she is no more representing the respondent in this matter. Stop. Therefore, nobody appears for the respondent today. Stop. No payment has been made by the respondent as was directed by a coordinate bench. Paragraph. Which police station will this be?
Not sure.
Respondent's address, see?
Lordship, that I have to get instruction exact police station.
No, no, cost title থাকবে তোর
Cost
address
title
নেই।
is Murshidabad, Bahutali Masjid, Murshidabad. It is
এটা কিছু দাও আমাদের petition দাও কিছু।
station is not mentioned.
এখানে কিচ্ছু নেই তো।
So far as the police station,
যা হয় কেন দাও। Is the address is here, Kadua, Bahutoli, Masjid, Murshidabad.
Murshidabad, but I cannot exactly determine the police station address, Your Lordship.
Jurisdictional police station?
Jurisdiction. Your Lordship, only one indulgence. Lordship kindly mentions jurisdictional police station. We shall inform.
Yes, you.
Ah.
Acha, paragraph. Oh, you had earlier served the respondent or you could not serve?
We have served the respondent by speed post also by way of letter dated 16th of April, but there's some speed by speed post we have served by speed post. But Your Lordship, the only difficulty is that the track report it is showing of 19th. The track report it is not served. We shall reserve.
Paragraph. Learned advocate for the appellant further says that attempts were made to serve notice on the respondent, but the same could not be done.
Your Lordship, it has been we cannot determine that.
Paragraph. Let the jurisdictional police let the officer in charge of the jurisdictional police station secure the presence of the respondent before us on the next date. So you supply the necessary particulars to the jurisdictional police station.
Shall I only
stop? The appellant shall render full cooperation to the
jurisdictional police station.
Extend full cooperation to the officer in charge of the police station. Paragraph lists the matter. When should we keep it, sir?
Any day as Your Lordship deems fit.
Next week. There you have it.
One indulgence, Your Lordship, there's a strong chance. I've got instruction that they will siphon off the vehicle by. So let there be an interim injunction that they do not siphon off the.
That we will, but of what effect will it be? ঠিক আছে করে দিচ্ছি কি বললো হ্যাঁ মে কত মে 13 2 weeks time we are giving you
Yes, we shall.
paragraph till the next date. Now, until further order. Until further order, comma, the respondent is restrained from dealing with, disposing of, or alienating the vehicle in question.
Deeply obliged, Your Lordship.
Come back on the 13th.
This is my first appearance also before Your Lordship.
First
First
appearance.
appearance, Your
Oh,
Lordship.
very good. So you obtained an order.
Yes, Your Lordship.
We'll come back, Mr.
Agreement 71 है तो Agreement 71 award 2000 बिल्कुल राष्ट्र ডিএফএম এ অ্যাপ্লাই করে দিয়েছি একটা টেকনিক্যাল ভুল করেছিল ওখানে সার্ভার কমপ্লিট পাঠাচ্ছি কি ভুল করেছিল ফাইলটা কোড 650 করে লিখতে হবে আমাদের তো কালকে একটা কল করেছিল
Smaller dam for the appellant.
Respondent, have
Mr.
you served?
Yes, yes, several times.
Oh, paper book ready.
Everything is ready, my lord. FMA of 2008.
Oh my God.
Well, it just takes the agreement of 1971 and award of 2000. And I have paid also, person to a director.
All very well. When was the last time this matter appeared?
Well, on 27th of February, my lord, kindly goes through the order.
The last order to the.
Well, two applications were filed on my behalf. Initially, it was Kolkata Municipal.
Kolkata Metropolitan Development KMD.
Initially, it was Kolkata Municipal Sanitation that authority. Subsequently, it was merged. So I took out an application. Thereafter, I came to know that the original plaintiff has expired. 3-4 years, they did not give us any notice. They are proceeding with the execution there. We are not aware of
What is the award amount?
Well, 14 lakhs or something, pursuant to the order passed by His Lordship, Honorable Justice Banerjee, Oshim Banerjee, way back. We have deposited 15 lakhs. Now they are enjoying, they're doing nothing. Well, every day notice and all. Well, last time also I gave notice.
He the head show. That. Hey. February 2025.
Yes, 27th February 25. This was the order, my lord, where I had taken out 2 applications.
Wait, you have a copy?
Yes, yes, certainly.
Can you file order nahi kya?
I took out 2 applications, both were allowed.
Original order.
Aage chalo water and sanitation.
The gentleman expired sometime in 2021. They are proceeding with the execution. They did not give us any notice. Only on 25 we came to know. Then we took out an application for substitution. Last year the sub 7th April.
Have you served a copy of the amended memorandum?
Everything by on 7th of April, stating that the matter will come up.
Give a notice to Mr. Kaushik Bhattacharya. You know him, na? Give a notice. Come back on Thursday or next week, whenever you.
Whenever.
Thursday. The respondent is not respondents of a substituted. Yes. Respondents are not represented today. Stop. But paragraph. Let learned advocate on record for the appellant serve a notice on learned advocate for the respondents, communicating that this matter will be listed again on Porshu dine date diye dao. Stop. If on that date, comma, nobody represents the respondents, comma, the matter may be taken up for ex parte hearing.
May I take back that order?
হ্যাঁ এটা দিয়ে দাও দুটো ফাইলেই কপি করে রেখে দাও বুঝেছো
গভর্নমেন্টে ফোন করছি
তাহলে আমি দিয়ে
এটা একটা বই বার কর
এটাই
ফার্স্ট টাইম একটাই ঢুকিয়ে দিয়েছি দেখ Item 7.
Yes.
My lord, I am appearing for the respondent number 1, my lord. Last occasion, court has direction given for filing my written notes of argument, my lord. I am filing my written notes of argument.
I am for the appellant, my lord.
Yes.
I am serving copy only.
You have filed your written notes.
Yes, my lord.
You have already filed.
Yes, my lord.
You want to proceed with the appeal today?
No, my lord. My lord, I have instructions. The arguing
Not to
counsel.
press the appeal.
Yes. The arguing counsel is not in Kolkata right now, my lord.
Where is he? Which
He,
part of the world?
he is in Orissa, my lord. Kindly fix the matter on 8th.
Who is the arguing counsel?
Alok Das, Advocate Alok Das.
8th.
8th.
Kindly make it 20th because my counsel is also coming from the Delhi, my lord. If my lord,
20th of May.
if possible, or my lord, kindly direct to what?
No problem. 20th is all right with us. No problem.
Much obliged, my lord.
করে দাও এসো written notes of argument filed on behalf of the respondent number 1 be kept with the records. Paragraph, learned advocate for the appellant seeks accommodation. Paragraph, learned advocate for the respondent number 1 requests the matter to be listed on May 20, 2025. Stop, let that be done.
Much obliged, my lord.
Pass over matter, item number 1.
এটা কেন টু বি মেনশনড কেন আছে অ্যাসাইনমেন্ট এতবার দেখি তো কি Oh, review of an order passed by Madam Chellur and myself. সেই জন্য আমাকে কাছে পাঠিয়েছে এটা তো অ্যাপেলেট সাইড ঠিক আছে কি করবো নট টুডে করে রেখে দাও কাল যদি না আসে ডিসমিস করে দেবো। কোথায় গেল কৌশিক?
এই বোর্ডটা
কমপ্লিট। কমার্শিয়াল
ঊনপঞ্চাশ
1744 প্রসিডি করার কমার্শিয়ালটা করো স্পেশাল
বলি original side matter commercial division item number 1.
Why to be mentioned, Mr. Mitra?
Yesterday, my lordship, this was the matter where transferred some department.
Oh, it has been numbered now.
Has been numbered.
Yes. Yes, দেখাও দেখিয়ে দাও না।
So, lordship, the entry model, lordship kindly explain.
Yes,
Well, if lordship says so.
Show it to your junior.
My real advocate on record, let them see it. এই যে নাম্বার পড়ে গেছে 22 এপ্রিল হয়ে গেছে নাম্বারটা, তুমি জানো না? 22 এপ্রিল
Department, they said that
22nd April, that we are today on.
ফাইলটা দাও ওদের, ফাইলটা দাও, ফাইলটা। আচ্ছা, লেখো, অর্ডার করো। The suit has been renumbered now as
নাম্বারটা বলুন।
has been there.
Item number 2.
Not I pay for the appellant. Not this is that interesting matter which I was telling your lordship. Not a nice point of law involved. Not so I'll just give your lordship not the legal point first and then get into the facts if required.
The paper books are ready. Paper books are ready.
Not, But it's at the interim stage, no paper. And there's a order against my bank accounts in an application where the learned judge felt that order 38 was not applicable, but I can pass the order under 151. This is the simple thing.
That can't be done.
Can't be done. But that's the order records. The order records it. This is the not short and simple point. They rely on a Supreme Court decision of Rahul S. Shah, which I'll show your lordship. But before I start off, but I have to seek your lordship's indulgence. I have to leave for personal reason, not in 15-20 minutes. So I'll just give your lordship the full overview, the judgments and everything is here. We were ready to argue it, but there's a little medical emergency which has come up.
No, you can go now also. If
it's not required to, because I'm supposed to reach at I just had a call saying I have to reach by a particular time. So if your lordship permits, otherwise I'll just start it off, give your lordship the germ of the idea behind it. Now, the matter is like this. A money suit is filed by my learned friends. Simple money suit, there is nothing else there.
By Pulak Modi?
No. Yes, Pulak Modi. Pulak Modi files a money suit, making claims against, in respect of an agreement. Your lordship need not be bothered by the papers. I'll take your lordship into the detail. Making claims for payment of money under an agreement which has already been terminated. No relief is sought with regard to termination of the agreement. Now, what was the agreement for? Agreement was for sale of shares, payment to be made in 3 phases, spread over a year. That company itself had no business. The company, however, held 100% shareholding in a company in Georgia, which was the lessee of a steel plant. Now, on signing of the agreement, the first installment was paid. They did not ask for the second and third installment, admittedly, because possession of the steel plant was never made over to me. Now, suddenly they write a letter. After 1 year, almost after a year, saying, look, pay me money. And that also 50% of the people who are selling their shares. So I write back saying, look, I'm surprised you have not asked me for the money because you could not give me possession because the statutory authorities have said there are fire safety violations, there are labor violations, and they've shut down the plant, and you've not appointed my people as directors of that company. You are still in control. No denial of those facts in their reply. When I write back, no denial of these facts, they admit it. They say money is payable. So I write back saying, look, since I've not got it, if you don't want it, refund my money and take back your shares. Doesn't deal with that. Files a suit again after 3 months delay or something like that. 3 months, you files a suit and obtains the ex parte order. So this is the background of the matter.
Suit filed in High Court?
Yes, High Court, not on the original side, ex parte order. Now, sorry. No, I'm sorry, not ex parte, order obtained, not matter heard. We applied for, we also applied for revocation under 12A and not other demurrer points. That is also, your lordship will find not satisfactory dealt with, but it's dealt with nevertheless. The learned judge then passes that interim order, and your lordship will find there are no directions for affidavits either at that stage. So we filed the appeal. During the pendency of the appeal, it was not pending for quite some time. We were trying to have the matter heard. It was heard from time to time.
The order was passed in August.
Yes. Now, the learned judge also said, very well, let me also see what is the value of the shares which you are offering to return. So, someone was appointed, what was the name of it? Ray and Ray was appointed to value it. They've also given a report before your lordship. I indicated there's a point of law, please hear it out. So he said, very well, that will not prevent, directed not that you can apply for, also file affidavits before the trial court, although there was no direction at that stage. Do that and we'll hear the appeal out. So this is the background of the matter, Lord. Now, the point before your lordship, please take it for me for the time being, Lord, that the order itself records that the principles of Order 38 are not applicable. It is not being applied for. And Lord, he says, but under 151 I can. Now, the order which is passed, Lord, surprisingly, is what not they had also not asked for. May I just trouble your lordship once with the praise of the plaint and the praise of the petition? Now, please turns to page 45. Page 45 is where the prayers of the plaint are set out in their application. I'm only showing it to show it was only a money claim.
$8.14 crore, yeah.
Yes, and the prayers are at page 32. Your lordship will find a large chunk of it is on account of damages. Now, if your lordship sees para 32, the prayers of the plaint are set out at page 46. So decree.
Money decree.
Money
okay.
decree. No prayer for setting aside the cancellation of the agreement, agreement under which these monies are claimed. And then, my lord, if your lordship comes straight away to page 50, which are the prayers of this application. Now, prayer A, my learned friends have tried to say again and again that the court was not asked to exercise or grant relief under Order 38. So I am showing your lordship the relief asked for. But page 51 are the prayers in the interlocutory application. An order be passed directing the respondent number 1, 2, 3 to furnish security. Now, my lord, under what provision can this be done? Can't be done under any other provision. Then, my lord, please see, where does this prayer for injunction come? Ask me to give securities prayer A, prayer B is in default. In default, an order of injunction be passed. So they did not really ask for an injunction on my bank accounts. That will follow on a default. The learned judge has granted this injunction against my bank accounts. Now, but as is the custom in the High Court, we don't mention the section under which a application is filed. So my learned friends have been asserting all along, this is not an application under Order 38. It's not an application under Order 39. This is an application under Section 151. That's the only way in which they can sustain the interim order. So they say this is an order under 151. The learned judge also says it's an order under 151. Conditions, he's not satisfied that conditions under Order 38, 39 have been made out. Because it is after I had argued not that Order 38, 39 conditions are not there, they argued 151. And they relied on Rahul S. Shah, which is not a case in which the Supreme Court was dealing with execution. In execution, there is one stray line on the basis of which they say, look, the principles in that judgment which relate to execution will apply in full force in all suits. Now, that principle has been busted perhaps by a Delhi High Court. It says that, look, that's too broad. It obviously doesn't intend to say that. It is in the context of execution proceedings, but that's neither here nor there. Supreme Court is Supreme Court. Now, I intend to show your lordship, number 1, an order cannot be passed under Section 151, where there are specific provisions for grant of that relief. That's the old established law. I have 4 judge bench decisions prior to this one. This one, I will say, Lord, is obiter or sub silentio in any case. This is what I intend to argue, and I'll show your lordship the judgments on that, not on the next day. Your lordship.
When do you want to tell us?
But whenever it suits your lordship.
We are here every day.
Lord, I
consult your diary.
Lord, I am a servant of this court more than your lordships. Other than on Friday afternoons, I tend to push off at times, but not other than that, not any day it suits your lordship. Not, because I'm the one
coming Friday. You are pushing off.
Maybe not.
Maybe not.
Maybe not. Your lordship can keep it. Not any day suits your lordship.
No, it can be day after tomorrow. It can be.
Absolutely.
Mr. Dotto?
No problem.
My two juniors in the matter are not there on Thursday. Give me a day.
Okay. Tomorrow also we are here if you like.
But tomorrow I have the special bench matter fixed on a difference between two
Give
benches.
us a date, both Mr. Chaudhary and you.
Whenever it's convenient to Mr.
No difficulty. বলো না তোমরা এত দেরি করে তুমি Okay, 7th of May. Not 7th of May suits him. No problem.
Mr. Bachawat, learned senior advocate representing the appellants, begins his argument but does not conclude. Paragraph. On his request, let this matter be listed again on May 7.
Obliged to. Oh, what is it? Someone photo?
Two line later.
Not to report.
Item number 3.
Lord, I am also not the appellant in this one. Mr. Bhattacharya was addressing your lordship on the last day when I was stuck. But can I make a similar prayer for this one?
Yes. Mr. Bhattacharya.
Rudraman Bhattacharya.
Acha.
Section 12A. Section 12A.
12A. Mr. Bachawat is in some personal difficulty today. When? 7th?
Keep it on that day. 7th. I have no problem. Lord, keep it on Monday, Tuesday, anything. Lord, I have no problem.
Monday, 5th.
Lord, I don't know what days your lordship takes it up. Problem
What's it?
Special bench
Okay. Sorry.
Larger bench reference
Thursday. Day after tomorrow.
Yes.
Accommodation is sought for on behalf of the appellant. Paragraph. As requested, let this matter be listed
Lord, I
again.
forgot same difficulty. Lord, my junior in the matter is not here.
Then-
My fault. Lord, I should have remembered. Lord.
Tell us.
In that both the juniors are not there. Lord, keep Monday. Right. Monday, Lord.
Monday.
Monday, if it suits your lordship.
Monday? No. Monday, Mr. Mitro says no.
I'm told, my lord, that it's the day of the monthly list, my lord.
Oh, I see.
Oh.
So,
But in that case, cut out the confusion. These two are appearing one after the other. Keep it on 7th, Lord.
May 7.
Make it 7th. One after the other, Lord.
non-commercial matter, item number 1 and 2.
Can you to be mentioned? Can you?
My lord, sorry, this was coming at my instance. I had mentioned, my lord, yesterday. My lord, Mr. Pradeep Ghosh is on Mr. Pradeep Ghosh's ground, my lord. He'll be arguing this matter. It was fixed possibly on 5th of May. Now, my lord, he's, my lord, undergoing for a.
You told us yesterday.
Yes, for a
We
surgery
remember that.
between.
So when should we keep it? After the vacation?
Right after the vacation. my
You
lord.
are for?
Well, the issue is I'm appearing under instructions holding the brief on behalf of the advocate on record. He has some difficulty, has asked for a short passover. So I am not really instructed as to whether.
We are keeping it. We are not hearing on merits, sir. Adjournment is sought for on behalf of
For filing of paper books.
Yes, Your Lordship.
The time needs to be extended on that.
Whose appeal is it?
It's my learned friend's
3 and
appeal.
4 are my appeals. This has come up at my instance. We were supposed to file the paper books for item 3 and 4. We are out of time by 3 days, Your Lordship. The paper. I appear in item number 4 for the appellant.
Lord, I
Your
appear for item number 3. The appellant in item number 3.
So you are in 4 and 5.
3 and 4 are our appeals. The cross appeals 5 to 7 are filed by my learned friends.
Madam, 3 is Kedarnath Tradecom.
My
Lord, I
learned-
appear for the appellant.
4 is Omkar.
That is my appeal.
5 is also Omkar.
That is
But
Omkar,
that
but that is the cross
cross-appeal.
objection.
Oh, I see. 6 is again Kedarnath. Cross objection.
That's also by me.
7 is also
7
That's by
Kedarnath,
me.
another cross objection.
Your Lordship. But what needs to be done also in the meanwhile, my lord, there are multiple applications which were filed. There were directions in those also. The pleadings are not yet complete. So I'm seeking extension with regard to those. Let 4 weeks be granted to us because there are 5 applications. In 5 of the applications, pleadings are outstanding.
So let the matter stand adjourned for 4 weeks. In the meantime, let paper books be filed, let pleadings in the applications be completed, let everything be done. Come back refreshed after your summer holidays and do the matter.
Grateful to Lordship.
একসঙ্গে order করে দাও একবারে 3 থেকে 7.
3 to 7.
On the request made by learned counsel for the parties, comma, let these matters stand adjourned for 4 weeks. Stop. Paragraph, in the meantime, let paper books be filed as had been directed earlier. Stop. Let the pleadings in the applications
GA number 2, 3, 4, and 5.
being GA2 of 2020,
2024.
4, comma, GA3 of 2024, GA4 of 2024, and GA5 of
2025.
5 of 2025 be completed in the meantime.
In both the appeals because same GAs in 2 appeals.
In 2 appeals, 3 and 4. Right.
In the relevant appeals.
Grateful.
Hello. আরেকটা লিখে দাও learned counsel for the parties are requested to come back refreshed after their summer holiday.
Grateful to Lordship.
Item number 8. Not, I am for the appellant. Not this. Not old appeal. Not has appeared. Not after a long time.
Your appeal.
Not my appeal. Not what had happened was some of the defendants. Not respondents. Not had expired. Not there was an order. Not for Not I'm carrying out the amendment. But that was not just on the almost not on the eve of COVID time. Not so. Not I just need to verify whether that has been carried out. Not could it
adjourn it for a week?
For 2 weeks. Not could it be 2 weeks?
You've just deprived us of the pleasure of dismissing this appeal. Mr. Sinha, common learned advocate, appears for the appellant and seeks 2 weeks' time. Stop. Paragraph. List this matter once again. দিয়ে দাও 2 সপ্তাহ বাদে ডেটটা দিয়ে দাও.
I'm grateful to Lordship.
Item number 9.
We are opposing this appeal. It's a very old appeal. I believe.
Passover, old appeal. Nobody would have ever listed these. We have listed these.
I know.
Passover.
Second call. Great.
Item number 10.
Passover.
Item number 11. Item number 12.
Not my appeal.
Your appeal. Passover.
My lord, there's only one small thing. We have an application here, ACO 4, my lord, where I'm seeking permission to file the Wakalatnama. The previous advocate on record is not giving the no objection certificate. So that technicality has to be
ACO 4.
ACO 4
is an application.
By where I'm seeking, my lord, permission for me to file the Wakalatnama. because the previous advocate on record is not giving the no objection
No,
certificate.
we
That-
don't know why he is not giving no objection. Maybe your client has not paid his fees.
Well, either way, well, we can't, well, we're not being able to proceed because well, she's not appearing also. So the new advocate on record has given her a letter asking for the NOC, which has not been granted. So, my lord, we were.
You serve a copy on your
Previous advocate on
yes,
record.
yes. ACO4 Act order karo.
CO4.
ACO4 now. This is an application of the appellant seeking leave to file wakalatnama executed in favor of a new advocate on the ground that the erstwhile, on the ground that the advocate, the present advocate on record, has refused to grant no objection certificate.
Has not granted. The
Has
refusal
not granted.
Not granted.
Has not granted no objection certificate, comma, in spite of requests. Paragraph, let a copy of this application be made available to the learned advocate who is presently on record. Paragraph lists this matter once again.
Next
Monday?
week, Monday. We'll serve it
Monday date dida.
Item number 3 and 4, 13 and 14.
Cholo.
15.
It's my appeal, Millard, appealing after a long time.
I prefer the official
Liquidator. Millard, I was praying for some time maybe given so that we can come back and collect the
1 week.
records. Some more time, say 2017 appeal. Somehow I have.
Your client is not interested, Mr. Dashgupta. It is at our instance it has been listed.
No, the issue is that it's relating to Millard the estate of Mr. Hoon, late Nirmaljit Singh Hoon.
Whatever the issue
Now, Millard,
be,
the issue is that Millard, it's from an interim order. Now, Millard, just
probably infructuous by
No,
I know. Look it up, come back after 2 weeks.
Like the official liquidator, Lord, that they don't have, Lord, the papers and documents of this case. So, Lordship, can you direct
he appeared. That's all right. That's all right. But
so that
Why make things complicated? Make a request, polite request, he'll give you. Adjourn for 2 weeks. Learned advocate for the appellant seek
Lord, I want to give your lordship the pleasure, my lord, of dismissing.
Huh?
Lord, I want to, Lord, give the pleasure, my lord, of dismissing. Lord, I deprived in one, Lord. No, this has been not settled outside court.
Excellent.
I'm for the appellant, Lord. It's been settled. Lord, they paid the entire amount. So,
Mr. Sinha, learned advocate appearing for the appellant, says that
First one matter, item number 9.
usual তুমি জানো তো dismissal না জানো না কি কালকে record the appearance of the respondent.
I'll give my
Item number 10.
Same চলুন.
Item number 11.
Same.
Item number 13.
Same.
13 and 14.
Same.
Item number 16.
Same.
New application, item number 18.
18. That one is to Mitra. The other one.
কিন্তু ফ্রি হবে
excellent. It will be reached.
Yes, well, this is my appeal.
That must be taken up next week. Yes, no problem.
Then, well, Kaushik, kindly extend the interim order. Fifth time not there, sixth, seventh, whenever, or should be interim order kindly. It's still
Shubhankar
the eighth.
Banerjee, Shumitra Bhattacharjee. I was in no way involved in this matter at any stage. No.
This was in 241, 397 petition, 10F appeal.
On the request made by learned counsel for the respondent.
Responded.
I am for the respondent, my lord.
Yes.
I have also filed my cross objection, my lord. Last occasion, your lordship granted leave. Your lordship take up the this appeal along with my cross objection, my lord.
But I am led by Mr.
I have
Chaudhary,
also
my lord. I
filed
am
the
taking
copy,
Mr. Shobhajay Chaudhary, my lord.
Chaudhary?
My lord, Shobhajay Chaudhary, my
Chaudhary,
lord.
yeah.
My lord, I pray he is not there. My lord, kindly keep it on any other day, my lord, tomorrow.
Day after tomorrow.
Let the cross objection
Being-
filed by the respondent.
Being OCOT number 4 of 2020.
Lekho, being OCOT number
4 of 2025, my lord.
be listed along with this appeal tomorrow. Tomorrow bole date ta diye dao.
Item number 20.
Lordship, in this matter, I appear on behalf of the appellant. Mr. Rotnanko Banerjee is leading me. Lordship, I'm praying for short Passover.
Oh, wow.
Item number 21.
My lord, I have made an application being ACO number 2 of 2025 in this matter.
No,
This is really.
I will not take up this.
I am not asking for any prayers as such, only discharge of the receiver. Because Mr. Deb is suffering.
Huh? Oh, Mr. Deb.
He's
for his discharge.
it's only for his discharge.
Very well, and then somebody else has to be appointed.
Yes.
You have taken out an application?
Yes, my lord.
Dekhiye application.
Whatever we have, my lord, one's fixed deposit with Standard Chartered Bank and another one with Punjab National Bank. That is annexure E and F at page 47 and 49 of
You
the
have served a copy on the OL.
Yes. OL has been served.
But
Oh, so of the two respondents, one respondent has not been. It has item as returned.
One respondent, there's only OL.
No, so to OL, Govind Sarda and Ghansham Sarda.
Govind and Ghanshyam are both applicants.
Yes, so Govind, in this application, yes, in this application they are respondents, and Govind Kumar Sarda has been served, but Ghanshyam Sarda has not been. It has come as item return.
Oh, this is an application of the receiver.
Yes, seeking discharge.
You have served on Govind and Ghanshyam both.
We tried to, Ghanshyam Sarda, it has come back as return.
Ashok Road, Alipur.
I do not.
Send somebody for hand service.
Okay, we'll do that.
Yes, do that.
We'll do that.
We'll also try and find out what
Their advocate, if we
Okay,
can
we
serve
can-
on their advocate.
Whatever. Let's serve that. This application has been taken out by the learned receiver seeking discharge on his health grounds. Paragraph. Let service of this application be effected on the other parties, on the parties, or rather, no, on the parties.
Answer, just one defendant.
One respondent.
One respondent.
On the
Respondent
applicant number 2, the applicant number 2, and affidavit of service be filed in court on the next date.
My lord.
When should we keep it?
1 week.
Paragraph, list this matter next Tuesday, Kurata.
Prayer in terms of A of notice of motion, short cost title.
Keep to file application by
Yes.
Prayer, there'll be there'll also be an order.
In terms of prayer A,
There'll be an order in terms of prayer A of the notice of motion.
much obliged. Notice of motion.
Item number 22.
Much obliged.
For the appellate.
Respondent?
Is always there.
Yes.
Now, my lord, I shall give a very brief background and then come to the papers, my lord. Well, it's a family dispute. Fight between, my lord, initially it was a fight between, my lord, the father and 3 sons on one side and the
reciprocal obligation.
Yes, yes. And, my lord, the eldest son on the other. Then they decided, my lord, to settle the disputes. Arbitrator was appointed, and then before the arbitrator, they filed, my lord, a settlement agreement.
You are father and youngest son? No, you are the
Yes.
father and young.
And two or three sons, my lord. I am not very certain about 3 sons. Father is no more there. Now, on the basis of that, my lord, agreement, an award was made in 2013. Thereafter, my lord, both the parties had put the award in execution. Both.
In this court.
In this court. In the execution was proceeding, my lord. The award provided for, my lord.
It has come back to us, Mr. Mitro. Your other side wanted to take one property out, that Jaipur property.
Jodhpur property. Yes. Now, during the pendency of that, my lord, they made an application that they want to take out Jodhpur property from, my lord, the list of, my lord, the properties in execution. Now, my lord, that application, possibly on the first day, my lord, was, my lord, allowed. Somebody was there, my lord. My advocate on record was not there. Somebody was told to take an adjournment. That is our case. He was told to take adjournment. My lord, I really do not know what submission he made. The order does not record anything. The application was allowed. Then, my lord, an application was made for recalling of that order, saying that, my lord, the person who appeared, he had instruction to seek adjournment but the order has been passed. The advocate on record, at that point of time, the person, it was a farm. The person dealing with it, he was unwell, indisposed of during the COVID period.
he did not or could not appear, so he was requested, somebody else was requested to appear. Now, the second, the application for recalling was also dismissed. So there are two appeals before this Honorable Court from that order. Now, initially, both these appeals came up before, my lord, a bench. My lord, a different bench, when that bench, my lord, after hearing the submissions, was prima facie satisfied that the obligations are reciprocal, so a stay was granted. At that stage, submission was made on behalf of the respondent that no, they want to proceed with the execution in Calcutta alone. On that basis, the appeal was disposed of. From that, my lord, they went to the Honorable Supreme Court. Oh, sorry. They filed a review petition. Sorry, yes, I made a mistake. They filed a review petition. The court was of the view that review is not really maintainable, but since it has been submitted, that the submission was made without instruction. So the second part, the appeal is disposed of, was deleted, and the stay was allowed to be continued. From that, they went up before the Honorable Supreme Court.
Sent back for fresh
Supreme
hearing.
Court has sent it back. Now, my lord, on the last occasion when it was taken up for hearing, my lord, I submitted before your lordships that GA1 possibly, my lord, includes all papers. So, my lord, may I proceed on the basis of GA1? In APOT, একটাতেই তো আছে, APOT 124.
Only one thing, Milad. GA1, Milad, my landed senior can rely upon, but Milad, GA1, Milad, was all practical purpose were disposed of. Milad, they were before the Honorable Supreme Court. Milad, the revival of GA1 was not placed before the Honorable Supreme Court. When it came back to Milad, Justice IPM Kaji's bench when Milad was here, Milad, they took this point to hear out GA1. Milad, I opposed Milad on the point that GA1 has been disposed of. Then Milad, only the appeal was listed with the Milad memorandum. Milad, only the appeal was listed. Now, Milad, they can rely on that. They can rely on that, but
I shall file paper.
But Milad, GA1 for all practical purposes has been disposed of.
Let them file paper. That will make things easier for us also. Huge. The objection needs to.
And they have filed another application for stay.
GA4?
Those are there. GA4, Milad, I have an application for order for 227. To which, Milad, they have not filed.
GA4 is your application?
Yes, for stay.
3 and 4.
3 and 4.
For stay.
If that has all the papers, proceed
Yes.
on
No,
that.
no, that does not have all the papers. That is why, my lord, on the last occasion, on possibly last week, my lord, I made submission that yes, GA4, GA1 has all the papers. According to me, my lord, GA1 is surviving. They are saying it's not surviving. I do not want to go into all these disputes. Now, my lord,
informal paper book. Then
I shall file informal paper book. In the meantime, my lord, I would also, my lord, press for, my lord, a stay.
My lord, I am opposing to that. They have filed a fresh application for GM.
Yes, in GA3,
GA4 for it.
Yes.
But I have a right to oppose.
It's not for my learned friend to, my lord, advise me what I should do.
I am not in an.
It is just kagoj.
Yes, yes. Anyway.
Proceed on this basis. Yes. Proceed on the basis of this. Whether GA1 is pending or not pending, as a bundle, a bunch of documents.
Lordship. Now, my lord, kindly, the award is at page 29. It's possibly slightly illegible. I'm not very certain, my lord, about your lordship's copy, but my lord, my copy is not very legible. In that event, if your lordships are pleased to look into award.
Yes, I mean.
Kindly look into, my lord, GA3. I'm sorry, my lord, I really do not know why it has happened. Kindly look into GA3, my lord, for the award only.
Page?
Well, it's at page 18. 18.
Page 18.
GA3, my lord, in APOT 124.
হ্যাঁ তুমি 141 দিয়েছো।
Oh, sorry, it's my mistake.
That is the order 41.
তো পড়িনি।
মার্ক করছিল।
Let kindly come to page 18. 18.
Yes.
Lord, I am omitting, my lord, the initial paragraphs. The parties were sitting together, then arbitration agreement. Kindly come to page 26. Paragraph 10, the parties appeared before the tribunal on 1st January 2013 at 5 p.m. and informed the tribunal that they have amicably resolved their disputes and differences. Then kindly turn the page. Paragraph 11. Inasmuch as the parties to the reference having agreed to a mutual settlement of various joint businesses, properties, assets, companies and firms as recorded in the document dated 1st January 2013 and as further agreed during the course of arbitration, sitting on 1st January 2013, the parties to the reference requested the tribunal to record settlement. In view of the settlement arrived at between the parties as recorded in the said document dated 1st January 2013, and as further agreed during the course of meeting on 1st January 2013, the arbitral tribunal passes the award in terms thereof, which are as follows. The properties and/or companies and/or firms under the heading Suresh Kumar Jain Group, that is, my lord, the respondent, the eldest son, will exclusively belong to the party of the first part and/or his nominee, and those under the heading Madanlal Jain Group, that is the father's group, will exclusively belong to the party of the other part and of their nominees as set out herein below and subject to the terms and conditions mentioned herein below. Now, pausing here for a moment, kindly come to page 30. The properties and/or companies and/or firms under the heading Suresh Kumar Jain Group. Kindly come to the first one, LMG Overseas Limited, having its registered office at such and such. However, the property at unit number such and such, DDA Building, Nehru Place, New Delhi, owned by the company will be transferred by the first party or and the company to the other party or their nominees. Veerprabhu Marketing Limited, having such and such, a registered office at such and such. However, land measuring approximately page 30, sorry. However, land measuring approximately 1500 square meter being half portion of land at plot number such and such, Barmer, Rajasthan, owned by the company will be transferred by the first party and of the company to the other party under their nominees.
First party is Suresh Kumar Jain.
Suresh Jain, the other party is the rest part. Then kindly turn the page. It is, however, agreed between the parties that the party of the first part will allow Messrs. LMJ Services Limited to use and occupy immovable property and plot number A11 Industrial Estate, Jodhpur for a period of 4 years from the date of this award at a monthly rental of such and such for the first year, rupees such and such for the second year, and for the third year such and such, fourth year such and such, which property is owned by Veerprabhu Marketing and allotted to the party of the first part under the award. The aforesaid monthly rent will be inclusive of all service charges, etc. Then kindly turn the page. LMJ Shipping Private Limited, having its registered office at such and such. LMJ Projects Private Limited. Then the particulars are given. Kindly come to page 33. Six, seven, my lord, are the companies given, particulars of the companies given. 8, Bengal Food Park Limited bearing such and such. However, the parties agreed that the party of the first part shall pay rupees such and such to the party of the other part as consideration. Then, my lord, the particulars are given. It goes on, my lord, 9, 10, 11, 12, all going to, my lord, the SKJ group. Then, my lord, page 39, Madanlal Jain. Then, my lord, kindly come to page 46. Clause 15. The tribunal appoints Mr. So-and-so chartered accountant of such and such address as custodian of various documents, deeds, instruments, bank accounts, properties, etc. to hold the same till the award is implemented in terms hereof, as also to take all steps required for implementation of this award, including issuing directions and or making requests to the parties. The parties will immediately make over all original title deeds and documents relating to all the properties, including supporting documents, for those mortgaged, hypothecated, pledged, kept under lien or with lenders, either standing in individual name or in the name of company, companies or firms, books of accounts, and or any other document relating to the company's firms and or business and or properties to Mr. Kamlesh Sogani. All the parties will duly execute the requisite number of demat instruction slip and or share transfer deeds and will keep such documents and or instruments together with original share scripts of all companies mentioned herein above in the custody of Mr. Sogani. The parties will call meetings of board of directors of respective companies to ensure approval and recording of transfer, transmission of shares of various companies in implementation of this award. Mr. Sogani will hold all documents including share certificates, share transfer instruments, minutes of the meetings, etc. till individual businesses, properties, companies, and firms are transferred and the guarantees given by any of the parties are released, discharged in terms of and in complete implementation of this award. Mr. Sogani will effect and or cause to be effected transfer of shares, requisite documents for, let kindly come to, and possibly, my lord, page 48 is a repetition, possibly.
Yes.
Kindly come to page 49. For control of firms and or businesses and or properties, once the parties discharge their respective obligation in terms of this award, and only thereafter will hand over the related documents to the persons who are entitled to receive the same in terms of the award. It is agreed between the parties that the assessment and or valuation of any asset, etc., my lord, it's not important. But this was, my lord, the award. Paragraph clause 16 is not required.
Nineteen,
yes. If any of the party fails and or neglects to perform their obligation and or duties as envisaged in this award, then in such an event, in addition to the penal clause mentioned elsewhere in this award, the defaulting party shall also be liable to pay sum calculated at rupees such and such for each day to the party not in default, till the time default continues and our obligations and our duties are performed by the defaulting party. Further, the defaulting party will not be entitled to receive any document and or paper with regard to allotments made in favor of such defaulting party till such time the defaulting party performs their obligation in terms of the award. So it is in addition to the other clauses. Now, my lord, that is possibly the award. Now, kindly come back to my lord GO1.
2 o'clock.
Huh? Oh. Very good.
কি অবস্থা কি অবস্থা পেছনে একটা গড়িয়েছে না আমাদের পেছনে গড়িয়েছে না এ তো এক্ষুনি নির্মাল্য ভ্যাঁক করে We know.
Number 22.
We know. You tell us. We can't tell you anything.
Only Mr. Sharma
Adopt
can do
it. You have adopted.
Only Mr. Sharma can do it because I am a member of Bar Association.
So am I,
I cannot
We have
proceed.
agreed that
He
Mr.
is only
Sharma
a member of only bar library, so he can proceed.
Library has not adopted it.
No, I do not. I really did not get the time to verify that.
We are here. If you wish to do.
No. I have
When?
never done this. I have not.
When?
I would pray, my lord, kindly keep it on 7th. The other two matters are there on 7th. It would be convenient for me, my lord.
We don't mind. We don't mind. Likho. Heard Mr. Mithru, Learned Senior Counsel representing the appellant. Appellant na appellants, dekhe nahi baba ogulo.
Appellant. Lordship.
এই ঘরের নাম কেউ দেয়নি সেনা নির্মাণ দিয়ে দেখছি
Personal matter, item number 20.
Mr. Banerjee is not there on 7th. Can it be on 8th, my lord? Or
Oi, आगे matter ta 8th में करो.
14th. 14th, my lord.
14th करो आगे.
14th.
Utilizing those 4 days.
Same place, my lord.
Oh.
We're supposed to go to places which are now Srinagar. We were supposed to go, but now
Don't even think about it.
because we have booked 9th, 10th, 11th, and but now with this present situation,
Absolutely not.
Lord, I should 20, Lord, that Lord with the
Yes. You're a member of Bar Association. When? Tell us when.
Tomorrow, day after, whatever.
Tomorrow?
Day after tomorrow, correct? Yes, day after tomorrow. Mr. Mitra wants it, Lord, on Friday as well.
Friday?
No, day after Thursday. Oh, Thursday,
Thursday? Kaushik, Thursday.
Item number 27.
But I'm for the appellant. I'm led by Mr. Owen Banerjee. He's a member of Bar Association. My lord, if it may be taken up on Monday, subject to my lord's convenience.
Are you a member of Bar Association? You're not. No, my lord. You're here? Monday rekhe dar.
I'm deeply obliged, my lord.
Item number 28.
I appear for the respondent. Because of the resolution, perhaps the other side is not there.
Not today.
Item number 29.
I am happy on behalf of the respondent award on this matter. So I'll let them, sir, or Mulshidon Shah.
Appear or disappear? Not today. Not today.
Item number 30. Item number 31.
31. I am 31. Your Lordship, 31. I am for the appellant. Kindly let the matter be fixed on Tuesday, Your Lordship.
On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on কত তারিখ বলে দাও?
Much obliged, Your Lordship.
In item 30, my lord, my leader is not there tomorrow. If it can be taken a day after tomorrow, my lord.
30 কি not today করেছিলাম, Thursday করে দাও।
Grateful.
Item number 32.
I appear for the respondent 32.
Lordship, I'm for the appellant led by Mr. Chayan Gupta, Lordship. Lordship, he is on his legs on code number 38, Lordship. Lordship, I'm paid for 10 days accommodation, Lordship.
10 days?
Yes, Lordship.
Why?
Lordship, last occasion, your Lordship direction us to file a substitution application regarding the defendant number 1 has passed away. But Lordship, there's some...
Leave.
Lordship, can he leave to?
No. You have to do.
Lordship, there's some documents we need.
When were you enrolled?
Lordship, 2021.
21. Are you a member of Bar Association? Yes. Adjourn for 10 days. She said 10 days.
Only thing, they had not yet supplied us with the details.
Details.
Of the will.
Who has details of will?
Yes, the reason being they had indicated that the person who has passed away had left behind a will. But if the will is not probated, then I'll have to bring the executor on record. But they had indicated that in the will, the beneficiary.
Have you written to them?
Yes.
My learned friend's plaint already discloses why they are not on record. The property was not inherited by the person who's died.
Anyway, Mr. Kaur, Mr. Gupta, sort this out between the two of you. We can only tell you where there's a will, there's a way. Come back after 10 days.
Perhaps the substitution application will also not be required because the son is already on record.
He's the only legal heir.
No.
He's the only legal heir. The widow doesn't inherit.
That is.
Because under the earlier will, the grandfather's will, the grandson has inherited. The mother and father were excluded. And that's a part of their plaint also. In the plaint, it's already added. My learned friend's plaint already discloses that.
If you argue everything today, what will you argue 10 days later?
But could it be any day after the 13th?
Yes, it can be. It can be 14th.
Item number 33.
33, I'm appellant, not today, my lord.
Item number 34.
My appeal.
Senior Mr. Kaur is appearing, I know.
He's there, Mr. Kaur is here. Lordship, kindly fix it.
Not today.
Item number 35.
5 is my opinion, not today. And makes it not today.
You're a member of Bar Association?
Of the library, but I've not been informed whether we have adopted it, but I think we will.
No.
I can proceed.
Pass no, adjourn, not today.
Grateful.
Item number 36.
And I am for the appellant, my lord. And only not today, my lord. We shall take our chance tomorrow, my lord.
Very well.
A lot of matters are being adjourned, so probably my matter will now be slightly
Come up.
So we'll take a chance tomorrow.
Item number 37.
My lords, in item number 37, I appear on behalf of the respondents. The advocates on behalf of the appellants are not here, so I'm.
Not today?
Not today, my lords. Grateful, my lords.
Item number 38.
My lord, I am for the appellant, my lord.
Dismissed.
My lord, I am prepared today. I'm prepared, my lord.
You want to do it?
My lord, I'm a member of ILS.
Up to you. We are not going to force you. You know about the resolution.
Member of the Incorporated Law Society, my lord. They have adopted the resolution. If my lord permits me, then I can seek an adjournment for today. Otherwise, I'm prepared to continue, my lord.
Entirely up to you. If you want not today, we'll grant it.
My lord, then kindly allows me an opportunity because otherwise it would be going against the resolution of the bar. I apologize.
Tomorrow, my lord.
Not today.
Obliged.
Item number 39.
Jinxed.
Has the library adopted it?
My lord, I met Mr. Chaudhary on the way. He's going to the library to have it adopted.
In any case, my lord, ILS have adopted it, so should be as a matter of course.
Not today, Shab, not today. Takachi.
29 for the respondent, but not today. I'm praying for.
Live streaming টা বন্ধ।
Lordship, in item number 9, I am